we have a lot of people who are solos listen to this. If someone calls them, it could be an overwhelming amount of work. Like, is there a number of employees where it's like too much one person handle, or they need staff, or coming at the firm structure, be able to handle this? How big a company could someone handle, or when should they say we need help? Or there's a lot
Well,
of nuances. Maybe they have an HR that can help you. How should
right.
we look at it to not get overwhelmed?
Sure. So, I mean, I'm solo. I have 3 staff, but for compliance stuff, I pretty much do it all myself. Um, what's the largest I've done? I had a hospital out in Fort Smith, Arkansas, over 1,000 employees.
Hmm.
So I got a few extra days, and we had some good HR folks out there that worked too, and we got it done.
Yeah.
And, no penalties, anything. Didn't have eyesight after I left Fort Smith, but I it was done. Um, Now, I mean, if it's a solo that doesn't have any experience with I-9 compliance, um, I strongly suggest you don't try on the fly. Um, I have done worked with an attorney in the Atlanta area where she had one. I think hers was actually an internal I-9 audit and not a ICE audit. And we did it together. She learned, and type things like that. So you're probably better off if trying to get some type of internal I-9 audit for a client, and then bring in someone who's experienced and can give you guidance so
Yeah.
that you can learn what you need to learn. Um, I've got a book that I co-authored, the I-9 and E-Verify Handbook. Second edition was issued 2017. The first edition was authored by Greg Siskin, so we're listed as co-authors in the second edition. Third edition should be out later this year if I can ever finish it. Um, so that's a great resource.
Hmm.
But I mean, I would never try to, if you're just totally cold on, I-9 compliance stuff, and you get a call, you probably need to refer that call out. And maybe you can get that the attorney you call it out to allow you to, co-counsel
Yeah.
with them so you can pick it up. But I don't think it's possible to, or it's not advisable. I guess it's possible,
Yeah.
not advisable to try to go it alone. And I don't know I mean, the thousands about as much as I've done on my own. There's some software that is in the works of being able to take the I-9s and put them into software and spit out a report. It's still not there yet. One of the problems is so many employers still do it by paper and writing, and you have different writing styles and whatnot that it's harder to read. So it's taken some time.
Yeah.
Hopefully that will come about in the future. In the near future, as opposed to the
I've encountered companies that have they have like paralegals that just focus on I-9 who help them on a regular basis. So when they get these raids, at least you're working with them. So there's some partnership to help either the HR or them to deal with the numbers. As you said, if you get 1,000 cases, it's hard to just do it all one. You need to go through this paperwork. Just the fact that someone pick it up and clean it up because it might be a mess, put it in some sort of order so you can read it. But
I agree.
yeah,
There's a large. I dealt with one of the large companies in Memphis, and I think they had 2 paralegals dedicated to I-9 stuff,
mm.
and they were of great assistance.
Now, one thing I wanted to ask is like you talked about just getting warning notices sometimes. What's the differentiation for someone not getting fined, and what could he do to make that difference?
Well, I mean, you could have a client that actually filled out their I-9s correctly, but that's going to be pretty few and far between. Though I will tell you, you might hear from a bunch of folks that swear they have good I-9s, but when you look at them, they're not. Um, you got to get in there and remediate where you can.
Hmm.
Uh, and hopefully you can remediate a lot of the mistakes. maybe some of these mistakes were made years and years ago, more than 5 years ago.
Yeah.
And later down the line, you can apply the statute of limitations on timeliness
Oh, they have
violations.
that. Okay.
Now it's not applicable to all violations on an I-9, just the timeliness one. So that's always a good one. You can definitely ICE won't give it to you in the beginning. You have to say, hey, that's beyond the statute. And they go, oh yeah, okay. Uh so um so that's I mean that's the big difference. Nice that you don't destroy any I-9s. That you have I-9s for everybody. I mean, if you except for that Chinese restaurant, if you don't have an I-9 for somebody when you get the notice of inspection, even if you go get it, you're normally going to get penalized.
Mm.
And it's really bad if it's some of your if they ask for terminated employees. They have a right to ask for terminated employees
Mm.
back 3 years. They usually don't go past 1 or 2. But if you find out you don't have an I-9 on some terminated employees, well, what are you going to do? I mean, they're terminated, they're long gone. You're not going to be able to track them down.
Yeah.
So, you're just going to have to, take the hit. I've got a construction company down in Florida, and they didn't have any. They had like 3 I-9s, and they'd gone through. Construction companies go through a lot of employees, and they argued, hey, I think they were all independent contractors. I'm like, no, they weren't. They were employees. And
Yeah.
we just have to. I mean, we're waiting for the fine. I'm sure we're going to get one. So that's that's the difference. Or they don't because you don't hire counsel or you don't hire proper counsel, you don't remediate the errors, and then so the I-9s go to ICE, and the ICE auditor says nope, 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 and says these are the violations. They issue a notice of intent to fine. You immediately give them notice that you're going to appeal it to Oklahoma, because that opens, you only have 30 days to do that. That opens the negotiations. That doesn't mean you really want to take it to Oklahoma. That means you just want to negotiate. And then, you make your best offer. Like I say, almost every office I've dealt with, except Chicago, has been incredibly receptive to negotiations. Chicago thinks they're not allowed. I'm like, well, I can tell you, it's a federal law, and everywhere in the nation except Chicago, everybody negotiates. So,
Yeah.
so we'll see. When push comes to shove, they may take my second offer. And you know what? If don't, and your client is willing, and you think you can save money if you take it to Oklahoma, then call their bluff and say, nah, we're not going to settle this. We'll take it to Oklahoma. And the good thing about taking it to Oklahoma, twofold. One, they just recently got a settlement judge program started. So you get a settlement judge involved before you get fully into litigation. Well, anytime anybody who's been around judges knows they want to settle. They
Yeah.
don't want to litigate. And so they're gonna push both sides. And as a practitioner, it's sometimes hard to push the government. If the government wants to say hell no, they just say hell no. But they got to now say hell no to a federal judge, to a Oklahoma judge.
Yeah.
And then if it doesn't work, you litigate. And I write an article every year. Well, last couple of years there haven't been enough decisions to warrant it from Oklahoma, but studying every Oklahoma decision on I-9 penalties.
Yeah.
And it's varied over the years, but I think I've been doing it since 2012, writing the article. But anywhere from 25 to 35% reduction if you litigate. And some of these times you actually lose all your all your arguments. The last one that was just issued like 2 months ago, the client tried, not wasn't my client, but the employer tried all these various arguments, and then Oklahoma said, no, 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 no. But then they said, but we don't really like the way that ICE formula is set up. It's not right. It's too heavy on this. And so, we're going to reduce you from 210,000 to 136,000,
Mhm.
something like that. It was about a 35% reduction, even though they really didn't win any of the underlying points. It was just Oklahoma didn't like what ICE was offering as their formula, and so they knocked it down. So that's one of the things I try to use it to my advantage in settlement. I said, hey, if I litigate this, on average, I'm going to be able to knock your number down by 35%. And I use that as an argument that you're being unduly punitive.
Yeah.
And how did we determine you're unduly punitive? Well, this is how much Oklahoma knocks it down on average. And it's been a extremely successful argument with various ICE offices. They're like, okay, yeah, I see your point. Or I think some of the ICE attorneys, they really, most of them only dabble in this. They're really, they're really in immigration court. They want to deport people.
Yeah.
And, once they figure out that they're up against somebody who knows what the hell they're talking about, they're like, I don't want to do this. I mean, I had one attorney literally admit to me, You know way, way more about this than I do. I don't really know that much. I'm like, I don't know why she would have said that. I think that's not a good way to start settlement talks. But hey, you know what? If you want to give me that advantage from day one, I'll take it.